All right, the next case is Vickie Humphrey versus Barbara Plum. Good morning.
Good morning. If it pleases the court, I'd like to reserve 5 minutes for rebuttal.
Certainly.
My name is Chuck Woldest. I'm here representing Vickie Humphrey, personal representative of the estate of Evelyn Wyant. We're here requesting this court reverse an order entered by the lower court. The lower court made a determination after evidence at trial that a trust document was duly executed as required by law and therefore valid. He also made a determination that it was not revoked by Evelyn Wyant. There's several problems with this determination. The first is whether or not there was even a trust. There is a document that is a draft, an unsigned draft of a trust. There is also a single page which is purportedly initialed by the
Well, there was testimony that it was executed, and there was some sort of certificate that the lawyer did that, there was evidence from which the judge could find that the trust had been executed, right?
No, Your Honor, there wasn't.
Really?
I thought the lawyer and the paralegal and the other person in the office testified as to their normal practice. There was a deed prepared which they said they would not have done had the trust not been executed, and some sort of a certificate.
Well, we still don't know what trust document we're talking about because it was clear from the testimony both by Mr. Larson and Mr. Willoughby, the two persons involved with this, that they don't know what the actual terms of the trust are. Because when they were examined relative to this single page that was initialed that was different from the draft of the trust, it did not coincide with the draft of the trust, and the determination of actually how the property was being distributed is not in existence.
Didn't the witnesses give a reasonable explanation for that?
Did who?
The witnesses, Mr. Willoughby.
No, they did not. They did not know why. They did not know how that happened. They did not know why they didn't have a copy. They didn't.
I thought they said they didn't have a copy because they had copier problems at the time and weren't making copies of everything, even though it was their standard practice. Wasn't that the testimony?
That they thought that the copier may have been not working that day.
The clients would have brought this page in because that's the page that they were considering changing.
That is correct, but that still doesn't give us a document, because obviously the document that they brought forth to the court was not the document that was executed. Obviously there were changes made. If the document was in fact signed, there were changes made at a later date. But all you have is one page. You don't have a trust document. Any other portions of that document could have been changed. You don't have a signed document. You don't even have the terms of the trust. And both Larson and Willoughby acknowledged they did not know the actual terms of the trust relative to that one single page that was initialed.
Well,
so I don't know how you even have a trust document.
I assume that the reason you were there is because there's some real estate deeded to the trust, right?
That I was there?
The reason that we were in court litigating about whether or not it was a probate asset or a trust asset was because there was some real estate that was deeded to the trust. Is that right?
There was one piece of property that was deeded to the trust. There were substantial bank accounts that were also titled in the name of the trust.
All right.
But no one...
So there was a trust apparently because there was real estate deeded to the trust.
I don't know that, Your Honor. I can deed a trust, real estate into a trust without having a trust. I can go down and set up a bank account with a bank without having a trust document. Because they executed a deed into a trust doesn't mean that trust actually exists.
The holding that you espouse here is that in the absence of the trust document that you cannot prove that there is a trust in existence. There can be no trust.
Well, we have no terms of that trust other than one single page, which really doesn't do much of anything. And their acknowledgement that they don't know what the rest of the terms of the trust are what does that give you? It gives you one page of a document that you don't know and can't prove that it was signed or not signed.
I thought there was that somebody came up with an unsigned copy of the trust, and that one page that they had the signed copy of was a bit different than what was in the draft.
It was different than what was in the draft. It did not mesh with the next page. So obviously the draft of the document, the unsigned draft, could not, if it was executed, if an actual trust document was executed, no one knows what the terms of that trust are, because
But again,
that draft was...
my understanding is that there was an unsigned copy of the trust that was found, and a signed copy of the dispositive provisions, which didn't quite mesh. Is that right?
There was one single page that was purportedly initialed by the decedents, yes. But it doesn't really go to the actual distribution. It only says it gets 60% to one side, 40% to the other side, but then doesn't even say how that gets dispersed. It trails off to the next page, which we don't even have. So we don't even know how that 60-40 was even to be distributed if that was part of an actual trust document.
Do you quarrel with the judge's finding that the trust, if it existed, was not revoked?
Well, I do, because we don't have any terms of a trust. I mean, we don't know what the new trust, if there was a new trust that was actually signed, provides for revocation or not revocation. And without the terms of that trust as to what the requirements are relative to revocation, the Florida statute under the trust code says that you can show by clear and convincing evidence. And she, in fact, went to Mr. Dittmer, an attorney, to draft a will and told him that there was a trust, that it was never funded, and that she thought all the assets were joint and that they could be disposed of pursuant to her will.
Hadn't she gone back to the original lawyer? Hadn't she and her husband gone back to the original lawyer at one point to talk about making some changes? He drafted some changes, but they could never get an agreement on that, and so it didn't go forward?
That was the testimony, yes, Your Honor.
Isn't that some evidence that there was a trust if they came in to amend the trust and couldn't agree to it?
Is that evidence that there might have been a trust? Yes, but what is the trust? We still don't know what the terms of that trust are except for one page.
But isn't that sort of a different issue? I mean, if there's a trust and there are assets in the trust, then those assets are not in the estate, which is what the trial judge was deciding. Then we have a different question about, you know, what the terms of the trust were, but in terms of the issue before the trial judge, the fact that there was a trust and assets in the trust would be enough to determine that those assets were not part of the estate, correct?
That's correct if you have a trust document, but I still don't see that there's a trust document.
Well, all the judge was asked to decide was whether it was an estate asset, right?
Well, that's all that the amended petition requested, was he make that determination. But he went beyond that and made a determination that it was that a trust was validly executed with the formalities of a will, which the testimony totally contradicted. I mean, that's a very strict requirement.
What testimony contradicted that?
Because all three of the potential probable witnesses, Mr. Willoughby, Mr. Larson, and Ms. Tyndall, all testified that they had no recollection.
I mean, the law is that testimony about the normal custom and practice and that it would have been followed and was followed is sufficient to establish that that's what happened, correct? I mean,
no, it's not.
Law on that. Do you have a case that says that?
The case, if you're referring to Carlton, that says custom and habit, which was cited by the appellees, all that court determined was that prima facie evidence relative to a possible will existed. And in that case, two things. One, they had a true copy. Here we don't have a true copy of what the document that was executed. And number two, it still said that it required that the document be executed with the formalities of a will. And that didn't happen here.
The witnesses testified that it did, correct?
No. The witnesses all testified they had no recollection.
But this is what we always do, and we did it in this case. We know we did it in this case because we wouldn't have prepared the deed if we had not had the trust document first.
In addition, the Carlton case, That went back on remand for additional evidentiary trial, and the court determined there was not enough evidence for that will to go forward. So that will failed. So obviously custom and practice is not sufficient because the court didn't allow that will to be admitted to probate.
Under the evidence code, the routine practice is admissible to show that the business acted in conformity with that practice, right?
Except that under the trust code and under the probate code, you must prove specifically that the witness is signed in the presence of the testator in the presence of each other. That is an absolute strict requirement. This court determined that in Price v. Abate, that in that situation where the testator signed, the witness, one first witness signed in front of the testator, called over the other witness 15 feet away, who signed, knew both of their signatures, and this court determined that that's not sufficient. They must all actually be present and be able to testify that they saw that person sign, that they signed in each other's presence. That is not here. All three of those people, and Ms. Tyndall even said, I don't remember preparing the document. I wouldn't know these people if they walked in the door. I don't know that I was a witness to this document.
Didn't they testify that their custom was consistent with the requirements for execution in conformance with the
That's not sufficient under Florida law to prove up the execution of the will.
And give me the cite for that, because that's just astounding to me that would be the law.
That's the statute. 732, that's the statute.
The statute says, go ahead.
The statute tells you the procedure that must be followed. The evidence code tells you what sort of evidence can be used to prove that that procedure was followed. And it seems to me that as Judge Torpy just mentioned, that the evidence code allows proof of normal custom and practice from which a reasonable inference can be drawn or not drawn depending on what the fact finder wants to do. But if a reasonable inference is, yes, this is the way we always did it, and the way we always did it complies with the execution requirements of the probate and trust code, why isn't that enough?
Because Price v. Abate says that's not enough. Price v. Abate says that those people must be able to testify that they were there, that they witnessed in the presence of the testator, that they witnessed in the presence of the other witness, and that the testator...
So it's your position that if you have witnesses to a will that have faulty memories, then that will can never be validated in court?
It will not. That's what the Price case says. I mean, that's been the probate practice for 40 years that I've been practicing, that's the strict requirement under the code, under the probate code, and that the trust code requires that it be executed without formality.
I think you're confusing the process that must be followed with what it takes to prove that that process was followed. I mean, it seems to me that those are two different things. I think we all agree that to properly execute a will or trust, you've got to do certain things. How you prove that those certain things are doing, I think, is where perhaps we have some disagreement. And, you know, maybe I'm wrong on that, but
Well, the Carlton case said prima facie, yes, but when it went down to the lower court and went back up on appeal in the 4th District, they did not allow that will to be admitted. So the custom and practice issue was only relative to the ability to be able to have an evidentiary hearing as to whether or not that document was properly executed.
But we had an evidentiary hearing, and the trial court said, based upon what I've heard, I think they followed their normal practice. I mean, the inference has to be they followed the normal practice, and if they follow that practice, it complies.
You're saying that a will can be admitted to probate? A will cannot be admitted to probate on that basis.
Well,
Cannot.
I think you and
Never has been. Not under the Price case, no. That custom and habit will allow you, without any testimony as to whether or not they all sign in each other's presence, will admit a will to probate? I'm not aware of that ever happening under Florida law on a custom and practice, and it didn't happen in the Carlton case.
So back to the question I asked you at the outset, if you are seeking to establish the existence of a trust and the document is unavailable, then you lose, right?
If there's no...
You can't prove a trust unless the document...
How do you carry out the terms of a trust if you don't have the document?
Okay, well, you just asked me a question.
Well, I don't know how you carry out the terms of a
is.
trust when you don't have the document.
So your answer is that's correct. You have to have the document.
Yes. It's an
Do you
express
have any
trust.
case that says that?
Well, it says under the trust code for an express trust, which is it has to be in writing. That's also part of the 732 requirements.
Mm-hmm.
Isn't it routine, though, that people can reestablish lost or destroyed instruments? And it may become an issue of whether there was an intention. If the instrument was, if I take my trust and I accidentally put it through my paper shredder with absolutely no intention of revoking it, if that can be proved, assuming that I've died now and I'm not around to testify, but there's adequate other testimony that I accidentally put it through my paper shredder without the intention to revoke it, can't that instrument, even though it can't be physically reproduced, can't that instrument be reestablished?
It can be reestablished, but it requires the testimony as to the contents. And no one was able to testify as to the contents of that will, that trust document that was redone.
Well, but does Judge Perry's ruling establish the contents, or does he say there is a trust, it was dated this, and then presumably somebody's going to have to figure out what it said?
Judge Perry at the end of the hearing said that I'm going to instruct my clerk to draft a document that denies the amended petition. The actual order that was signed was prepared by the appellee's attorney, and it says that the trust document was executed with the formalities of a will, and therefore it's valid. But there's no evidence that it was executed with the formalities of a will.
All right, sir, you got about 3.5 minutes if you'd like to hold on.
All right, and I'll retain the rest.
Thank you.
May it please the court, my name is Jean Henney and I'm representing the appellees in this appeal. There are Judge Perry made 3 findings: that Mr. and Mrs. Wyant's trust was valid, that the trust had not been revoked, and that the trust assets could not be transferred to the estate of Mrs. Wyant.
Do any of those rulings establish what the terms of the trust are?
At the hearing below and at a closing argument, counsel for the appellees argued that the best evidence of the terms of the trust was the signed initial page. That's not specifically set out in this order saying that the terms of the trust at the signed initial page, but that could be inferred from the ruling and from what was argued and
presented. But the written order, would you agree if we just look at the written order, it doesn't say what the terms are or are not? It doesn't say whether I'm a beneficiary, you're a beneficiary, anything else. It just says there was a trust, it was executed on June the 16th or whatever the date was, and that the assets should not be put into the probate estate but rather into the trust. That was it, wasn't it?
That's the gist of the face of this language of the order, yes.
And that's all he was asked to do, Judge Perry, right?
So,
yeah, what he was asked to do was determine whether these assets that were entitled in the trust could be put in the estate.
So if somebody wants to squabble about what the trust provides, in other words, whether you're a beneficiary or somebody else a beneficiary, that arguably could be a different fight for a different day.
Yes, Your Honor, we do recognize that. I don't believe that this order would be res judicata to the issue of basically the difference between the copy of the trust and the signed initial page, although there was evidence presented at the trial that the signed initial page was the best evidence of their intent. We would argue that there was substantial competent evidence as to the validity of the trust, that it had not been revoked, and that the assets did not belong to the estate. As to the issues that were being questioned about the discrepancy in the initial page and the copy, Mr. Larson and Mr. Willoughby, on transcript page 98 and 113, they both testified that it was possible that the Wyants made changes when they had come in, that the changes were made on the word processor, and that set them off the page numbers a bit, but that the best evidence of the intent would have been the signed initial page. We would argue that there was no abuse of discretion in the finding, and that we would also argue that the appellees would be entitled to attorney's fees for arguing on appeal, and we have requested those.
What's the basis for fees?
The basis for fees is under the estate statute, that we provided a benefit to the estate by carrying out the intent of the testator.
Well, but doesn't that statute deal with wills, not in trusts?
It deals with wills, but the issue involved here dealt with whether two nieces would inherit well over $1 million in assets, or whether 31 nieces and nephews would split those assets.
Right, but I mean, at the end of the day, the issue was, does it go into the probate estate or does it go into the trust? The probate code has a provision that you seek fees under that says if you render services that are a benefit to the estate, you can seek fees, right?
Yes.
And that's what you're seeking fees.
That's what we're arguing.
Okay. What's the benefit to the estate here?
Well,
in fact, you sucked money out or prevented money from coming in, not the other way around.
The benefit to the estate doesn't deal with the beneficiaries, it deals with the testator, her intent, and her intent.
Well, that's not what the statute says, is it has to be a benefit to the estate.
One of the benefits of the estate is accomplishing the intent. That would be our argument. One of the problems with the personal representative is that she had collected trust assets already, that some of the financial institutions ignored the title on the
well, I'm assuming that, if the judgment stands up, that's another issue for another day.
Right, but that would be something that had happened as the personal representative that was corrected because the appellees have taken their position.
Okay. Well, we think we understand your position.
Okay, thank you.
You've got about 3.5 minutes remaining, sir.
Your Honor, just to point out, the order also indicated that the document, whatever it was duly executed as required by law, and that it was not revoked, but it was not duly executed as required by law under any form or any statute or any case that I'm aware of. I again cite to the Price case that this is a very strict requirement. In Carlton, again on the issue of custom and habit, only was a prima facie issue, and when it went back down to the lower court did not admit that will to probate because there was evidence that it was not properly executed in accordance with the requirements under the statute. So it has to be reversed because there is no evidence, there was no evidence at trial that it was properly executed, that it was executed as required by law.
All right, thank you.
All right, thank you so much. We will take a very brief